My name is Claire Bright. I am assistant professor at the Nova School of Law, and I am the founder of the Nova Center on Business, Human Rights and the Environment. It is a pleasure to welcome you today for this fourth episode of our webinar series on business and human rights developments in Southern Europe in the wide sense. So today the spotlight is on Switzerland, in which important developments have recently taken place, as you know. In particular, the popular vote that took place on the 29th of November on the proposed Responsible Business Initiative will be discussed, although the initiative was eventually rejected as it did not obtain the majority of the content, it still obtained a popular majority. And so today we have a stellar panel of speakers who will analyze the vote and analyze its implications for business and human rights in Switzerland and beyond. I would simply like to express my gratitude to our speakers who have accepted our invitation today. It is a privilege and an honor to have you all on the panel today. I am also very thankful to my colleagues from the BICL, Irene Pietro-Paoli and Lisa Smith, who have helped coordinating this webinar series. And I would also like to thank very warmly our wonderful chair, Robert Mccorquadel, who really does not need much of an introduction. Robert is a professor of international law and human rights at the University of Nottingham. He is a barrister and mediator at Brick Court Chambers in London, and is the founder of Inclusive Law, which is a consultancy on business and human rights. He has over 25 years of experience working in the field of business and human rights. He has published very widely in the area and has advised business, assisted governments around the world, and been involved with civil society, industry and organizations in drafting legal changes and in litigation. In particular, he has appeared as an advocate before the International Court of Justice and the United Kingdom Supreme Court, and he has a legal expert also before United Nations bodies. Before I turn the floor to Robert, I just wanted to let everyone know that the webinar is being recorded and that the recording will be made freely available on the website of the Nova Center for Business and Human Rights and the Environment after the event. Robert, thank you so much again for being with us today. I will pass you the floor now.
Thank you very much, Claire, and thank you to you for your innovation and energy to produce this panel, but also the series you have. And thank you to Irina and Liam and Lisa and those at BICL who've helped very much put this together. And just over 2 weeks ago, as you know, the Swiss people voted in a popular vote on a constitutional federal initiative. This panel will discuss the outcome, the context, and the consequences. And as Claire said, it's a fabulous group of speakers with different backgrounds, different interests, and different expertise. I'll introduce them all now in the order in which they'll speak. Urs Riebe, who represents the NGO Public Eye in the Swiss Coalition for Corporate Justice, a network of over 130 Swiss NGOs that launched the Swiss Responsible Business Initiative, which was, of course, the basis for the popular vote. Then we've got Dorothy Baumann-Pauli. She's a professor at Geneva University School of Economics and Management and directs the Geneva Center for Business and Human Rights, which is the first human rights center at a business school in Europe. Bravo. Liz Almless teaches at the University of Freiburg and is an independent researcher and consultant who has worked in the field of business and human rights since the early 2000s and has been more recently advising trade unions and investors. Anya George is a partner in the law firm Schellenberg Wittmer Limited in Zurich, where she regularly represents state-owned enterprises and also advises clients on business and human rights issues. Nicolas Bueno is a postdoctoral researcher in international human rights law and international economic law at the University of Zurich, as well as being a senior lecturer in international law at the Università della Cesare Italiana. and he previously conducted strategic litigation on business human rights at the European Centre for Constitutional Human Rights in Berlin. And finally, Sarah Deckish advises companies in how to embed responsible business conduct and human rights throughout their business operations. She's also been working with the Swiss government on the implementation of the Swiss National Action Plan on Business and Human Rights, as a member of the advisor committee to the Responsible Business Conduct Working Group of the European Parliament. So you see there's breadth and depth of experience here. The format of it will be that rather than each person speaking for 10 minutes or so, we'll break up the speakers. So 2 speakers or 3 speakers will discuss a key issue, and then the same will happen for another key issue. And we're covering 5 key issues in total. I hope this assists in the accessibility of the presentations. And after this, we'll have time for questions. I encourage you to put your questions in the chat box at the bottom of your screen. Then that'll appear on the side for all of us, and I'll gather them together and put them to speakers, or if the speakers can give a quick reply, they can. So please remember to put your questions there, and do so whenever you have a question. Please don't just wait till the end. Okay, let us begin. My first question is Andoro. What was the question put to the popular vote, and what happened? Yes. Urs, you're on mute.
Thanks. Hello, everyone. Thank you, Robert. I'm glad to make a first go on what was the question in Switzerland, and we will certainly have the opportunity to dive into more details during the webinar. So what happened in Switzerland is that the population had to vote on the Responsible Business Initiative put forward by a large coalition of NGOs, but also churches, businesses, supported by a broad coalition of political parties. And the most visible signal of that debate, one of the last flags that I had in stock, I hang at the wall for this webinar, because that really has been somehow the public the public sign of this campaign now in the last couple of months, but even years in Switzerland. So you have seen those flags in the cities, obviously, but also in small villages, at houses, in gardens, but even in the mountains, up in very remote areas, you would see them between the goats on the Alps. So that has been somehow the visible part of a very large support. There have been 80,000 such flags around the country, and it has shown over the last couple of years that responsible business conduct really is an issue in Switzerland that moves people, that brings people to a point where they get engaged. And over the last couple of years, the coalition was supported by a network of volunteers, of citizens that got engaged in a very large number, how it has never been in Switzerland. So we had 10,000 volunteers working in 450 local committees, being on the streets, informing about the initiative, hanging up the flags, bringing information materials to people's mailboxes, and so on. An incredible movement that has now reached a milestone. However, not a full success, I would say, but a respectable result and an important milestone in the debate. As Robert already has said, there was a majority of the population that said yes, a slim majority, but nevertheless, a majority of 50.7% of all the votes, which means about 40,000 people voting, more yes votes than no votes. But there has been a shortage in cantons where the majority of people approved the initiative. So Switzerland is organized in 26 cantons, And what you would need for such a constitutional initiative is that at least 12 of the cantons have a majority of the population that says yes. And so there was a shortage of about 6,000 votes. So you could say the votes were here, but they were not exactly in the right cantons in terms of distribution. But that's part of the challenge, and it's part of the political system in Switzerland. It is only the second time in history since the 19th century that you have, with a popular initiative, a yes vote of the population and a no vote of the canton. So that shows it has been a very narrow race. What is interesting in terms of the subject is that the cantons where the multinational enterprises are sitting, are located, they were all very much in favor, with the exception of Zug, in the center of Switzerland, where a lot of commodity traders are located, but all the other major business locations such as Zurich, Basel, Geneva have been, also the Ticino, Lugano, have been in favor of the initiative. I quickly wanted to summarize what it means in terms of content, what we have had to decide on, and I prepared a slide which I quickly try to share. So if we look at what was discussed in Switzerland, there is the Responsible Business Initiative, but we will later in the discussion come to two parliamentary counter-proposals, and I already put them here on the slide to have a comparison how they relate to the Responsible Business Initiative. So the Responsible Business Initiative, in terms of what are the duties regarding due diligence, it really has been a horizontal mandatory due diligence approach with all the 3 steps in the UN guiding principles and the OECD guidelines. So to identify risks, to act upon that, certainly also track what you have done, and then to report on it. The scope has been along the whole value chain, according to the international standards. The thematic scope has been human rights and the environment. The personal scope has been a focus on large companies. There was no exact threshold in the constitutional text, so some details have to be left to the implementation regulation, but it was obvious that it would have been for companies above 250 employees, and that it would also include SMEs that have particular high-risk activities ongoing, but that there would be exemptions for the rest of the SMEs. And then the most debated point was the enforcement mechanism. So there was a civil liability provision proposed, which would have included the parent company, but also the whole corporate group. So if part of the corporate group would have caused a damage that is a human rights violation, so a tort that is also a human rights violation, the parent company would have been able to be sued, except if it afterwards in the procedure could have shown that adequate due diligence was taken. So there was a due diligence defense mechanism. And Parliament reacted to our initiative, which is a possibility and quite often a dynamic that happens in Parliament when a popular initiative is filed. So the counter proposal that first was proposed...
Can I just interrupt you there, Urs, and maybe we'll come back to that last part later, because you've set up the setting of the particular proposal very, very well. And if we can come back to the counter proposal, I think would help in a later position. Is that possible?
That's possible, but perhaps I can make one more sentence?
Of course, of course.
So there was one counter proposal that was very similar to the initiative, and there is one counter proposal that is now being entering into force after the result that we now had, which is quite different from the initiative.
Great, thank you. I really appreciate that, and that's brilliant. Now we go to Doro for your response. Thank you, Urs.
Thank you everyone for having me. It's great to be here and see sort of the clustered Swiss expertise on this topic around this virtual table. Urs, thanks for laying out in such great detail what was on the table at the time. So in this round, I think I'm the only representative of management scholarships. I'll also react to what happened here from a management perspective. So what happened was indeed the referendum or initiative was rejected by a slim margin. Unfortunately, leading up to this historical moment for Switzerland, I was watching many debates between the opponents and the adversaries and of these and the advocates for this initiative. And it was remarkable in that the closer we got to the vote, the less they could talk to each other. So it was an incredibly polarized and incredibly politicized debate. It became a bit boring because I heard the same arguments from each camp and there was no overlap anymore. And so it became a decision over sort of who would win, who would lose. And in the end, you know, unfortunately, if it would have been accepted, the companies would have had to implement this. And I saw very little chances for a motivated adoption of this initiative at this point. So understanding the political process behind it and how polarized it had become, I think is important to contextualize what happened here. In conversations with many multinationals that were no longer willing to speak up about the initiative because it was so politicized, and I talked to multinationals that have been doing and engaging in business and human rights for over 2 decades. They signed up for the UN Global Compact in 2000 and they were in principle very committed to these topics, yet they felt it's not safe to speak up for the initiative anymore because of the politicized nature of it. And because there was a lot of unclarity from a management perspective of what would that exactly mean for their business context. And I think the 2 big questions were, first, what is adequate due diligence for a company in the food and beverage sector, for a company in the construction business, for a company in the tech sector? So adequate due diligence just wasn't defined and they felt uncomfortable signing up for something where they didn't fully get it, what that would mean for their daily business operations. Second question that many multinational companies discussed with me in private was, of course, the question around civil liability and how deep that would go into the supply chain. The key phrase here was control over companies. So does this mean that suppliers are part of this or not? And I know that the advocates of the initiative think that they provided clear answers to that, but apparently not clear enough for many multinationals to support this.
That's brilliant, Dora.
I'm not endorsing what they say, but I think it's important to acknowledge the questions that were out there. So.
No, it's a brilliant segue into my follow-up question, which is to Liz and Anya. How are business and investors engage in this process, and to what extent do they support it? So I'll start with you, Liz.
Thanks, Robert. So actually, a number of Swiss and non-Swiss investors did publicly speak out in support of the initiative. There were several investor members of the Swiss RBI coalition, Ethos Foundation, which is a foundation of over 200 pension funds and has a services and advisory wing, Actaris, which is an investor coalition, Oikocredit, which is a social impact investor. Why would investors support something like this? Well, one goal of the RBI, had it passed, would have been to prevent and remedy human rights abuses overseas associated with Swiss multinational companies. And if the RBI had been voted in and properly implemented, one effect would have been, by definition, better behavior of Swiss multinationals overseas. And I think for investors, the implications of that are clear. It would mitigate an enormous area of risk, legal, financial, operational, reputational, associated with their investee companies. One could say that investors should care about their companies respecting human rights and the environment overseas because it's the right thing. And I think this argument was made quite successfully by the campaign, that if it's not acceptable behavior at home, why should it be accepted overseas? But even setting that aside, if investors didn't accept the human rights argument, I think the self-interest argument was also quite strong behind the initiative. And just to lay that out from an investor point of view here, the public is increasingly linking badly behaving companies with the entities that invest in them. You hear the term follow the money all the time. And investment that's focused explicitly on ESG, or environmental, social, and governance factors, a segment that we loosely call SRI, socially responsible investment, is growing rapidly. Just to give you the numbers from Switzerland, the Swiss Sustainable Investment Market Study of 2020, which looks at figures up to 2019, reported recently that sustainable investments, broadly defined in Switzerland, reached 1.16 trillion Swiss francs. Now, that was a 62% rise from the previous year. And there's lots of reports from different regions of the world showing a similar rise in interest in what we loosely call sustainable investment. And that growing subgroup of investors is increasingly speaking out in support of precisely the kinds of issues that the Responsible Business Initiative sought to address. To give you two concrete examples, earlier this year at the global level, not just Switzerland, in April of this year, 105 investors with $5 trillion of assets under management put out a public statement supporting generally mandatory human rights due diligence. And they argued that that kind of regulation is, quote, materially good for business, investors, and the economy, unquote. And they also argue that the spread of this kind of law helpfully levels the playing field for companies and investors, and it allows investors to fulfill their responsibility to respect. And there's more and more scrutiny on that aspect as well. And then the Responsible Business Initiative itself, as a second example, during the campaign, 27 institutional investors, not just from Switzerland, but also from other countries, and that included Ethos Foundation, it included Banque Safra Sarrazin, BMO Global Asset Management, a group representing over 800 billion Swiss francs, sent a statement to the upper chamber of the Swiss Parliament supporting legislation for mandatory human rights due diligence as envisioned under the Swiss RBI. And the head of Ethos Foundation, which was a signatory, was quoted as saying, quote, reputational and operational risks related to human rights and environmental breaches have a significant negative financial impact on the companies in which we are shareholders, unquote. I think it's interesting that that statement was joint. It was Swiss and foreign investors, and that demonstrates the importance of Swiss companies for both Swiss and non-Swiss investors, and the stakes for the wider investment community of the vote. Back to the original question, did investors support it? Possibly more Swiss investors supported the RBI concept, but not many said so publicly. And this, maybe this gets back to Dora's point about the polarization. Vincent Kaufmann, who's the head of Ethos Foundation, he was quoted in a newspaper article last month saying that he was quite surprised that more investors didn't speak out in support of it, because as he put it, what the RBI was demanding was very much aligned with what sustainable investors want. So in short, I think a large swath of institutional investors do recognize the value of a coherent and consistent set of laws to prevent companies being involved in human rights violations and environmental destruction. Obviously, investors are not monolithic. Many of them still maintain what you could call a narrow, rigid focus on financial materiality, not really looking so much at the risks to rights holders. But I think that an increasing percentage of investors are long-term focused and are coming to understand the risks of poor corporate human rights practices on all stakeholders, including themselves.
Thanks, Liz. That's a nice segue with what Dora said. It's really helpful. And thanks for putting the bigger context. Anya.
Well, I think, as Liz said, Dora really put her finger on the issue. Also, when it comes to the position of businesses, there was quite a clear shift sort of between the beginning of when the initiative was introduced and then the debate that was being had right at the end and the positions of businesses. There was always a degree of support from some businesses, mainly though the smaller local businesses. There was a coalition, a committee of responsible businesses of about 90. Like I say, the smaller local Swiss companies, which arguably may not have been as directly affected by the new requirements or by any risk of civil liability. And that again brings us to the crux of the point. The debate very much focused on civil liability, and that was also the key concern for businesses. Dora mentioned, you know, there was a degree of uncertainty as regards to what due diligence, what the standard of due diligence would be. There was a degree of uncertainty with regard to these notions of control, and that very much came through in the debate from the businesses side. You had the two main associations, Économie Suisse and Swiss Holdings, who came in with guns a-blazing, literally focusing on that, saying that the initiative would lead to a wave of complaints against Swiss businesses, that we would be completely swamped by lawyers, you know, trying to make their cheap buck on these cases. And that led to that being sort of the core issue that businesses were focusing on. And I think, as Dora said, to a fear as well of taking position one way or another. Nestle, for example, you know, who have been very outspoken about their efforts to implement human rights due diligence and reporting requirements, came out very clearly against the initiative, saying specifically it would lead to foreign cases in front of the court. It might lead businesses to withdraw from risk areas instead of engaging with local issues and local populations. So that very much sort of seemed to be the polarizing element of the debate for businesses. There was a group called the Groupement des Entreprises Multinationales, based mainly around the Geneva and Le Mans area, that initially, I think, spoke out in support of the first counter proposal that was mentioned, which was relatively similar to the initiative and actually did include a liability provision. But then as time went on, they didn't make any further statements. And then what we saw was that when the second counter proposal came out, which removed the liability provision, businesses rallied essentially behind that proposal. So that was it. You had a few businesses who dared really to take an open position, and I would say that those were the businesses that were probably not going to be at great risk of any reputational damage in case the initiative would have been adopted. And there were some brave ones in there that you know, that really did stand out and take a stand. On the whole, though, I think it's in contrast to what Liz said. It can't be said that there were behind the doors there was a lot of support. Behind the doors there was a lot of uncertainty, and I would say a degree of fear as to what the initiative might bring.
Thank you, Anya. It's nice to bring in some of the diversity, sometimes between business and the organisations, trade organisations. Thank you, that's really helpful. I'm now going to take us back one step, which is, why did this happen at all? Why did we get to the stage of having a popular vote? I'm going to start with you, Nicolas.
Yes, well, hi everyone. Thank you, Robert, for the question. So I will answer your question of why there has been, after 4 years of negotiations between the civil society and the political parties, why it hasn't been possible to find a compromise, to find an adequate counter-proposal that would have led to the withdrawal of the popular initiative. And if you allow me, I just want to show you one slide. I hope you can see it. Here on these slides, this is a comparison between some elements of the Responsible Business Initiative on the left and the first counter-proposal on the right that has been rejected in 2020. But these counter-proposals had been adopted by one chamber of the parliament in 2018 within an entire process of negotiation between the civil society, some political parties, and the chamber of the parliament, in order to lead to a withdrawal of the constitutional initiative and therefore a popular vote. And I think, Doro, Anya, you also addressed the main difficulties to find an agreement on many issues. So basically, what I would like to do here is really to show you how, or what were the really problematic points in these negotiations. The first was probably not regarding this idea of including a due diligence obligation, as you all said. I think this is something that is pretty clear. Maybe, Doro, you have another view, because maybe it's still not clear enough what is this adequate due diligence obligation will look like in practice, and it still have some legal uncertainty. But the idea of this counter proposal in 2018 that has been adopted by one chamber was really to include this due diligence obligation quite similarly as in the constitutional initiative. However, this would have been really clearly limited only to large companies and some activities at risk. So this was the first compromise that has been accepted by the civil society, which said, okay, this is for us, for a withdrawal of the initiative, if I'm correct. The second element was really to discuss the central topic of legal liability. And the counter proposal adopted by the National Council aimed at keeping this provision of legal liability. This was really a condition from the civil society. Without any civil liability, there would have been any possibility to withdraw the constitutional initiative. And some compromise have been made on both sides. The first is that this legal liability provision, which was a specific liability for controlling company for the damage caused by their controlled companies. And the compromise were in three directions. The first, that these legal liability provision would have been applicable only to these large companies that have a due diligence obligation. The second was that clearly this would be only limited to parent company liability, and agree. There was some expression in the constitutional initiative that might not be as clear as in the counter proposal. Here, the main discussion was really to exclude any possibility of liability for the damage caused by a controlled subsidiary. It's still possible that it effectively a subsidiary can be controlled, but they wanted to exclude this possibility. And finally, in 2019, so these counter proposals hold for 2 years. And in 2019, and towards the end, it was still not very clear whether the second chamber would accept this counter proposal. And therefore, there has been a third compromise that have been put to it. So just to tell you how negotiations were really in good faith from both sides, and they aim to include another prior mechanism, a mediation proceedings that companies and that the parties would have been obliged to use before going to courts under this legal liability provision. Now, what happened with this has still not been sufficient for the second chamber of the parliament in 2020. And they prefer to adopt really a weaker counter proposal without any possibility for legal liability or any specific provision for legal liability. And this is why at the end, during these 4 years, and I will finish here, there hasn't been any possibility to find a compromise for the withdrawal of this constitutional initiative. And this is why there has been this vote on November 2020, well, last month. And maybe later we will be able to discuss more into details on the second counter proposal that will then enter into force, very likely in Switzerland. Thank you very much.
Thank you, Nicolas. That was very clear and very helpful. Thank you. You looked at this issue also, obviously. Can you appreciate your comments on this?
Yes, so I think it really has to be seen as a conversation that was going over a couple of years now, and the popular vote is only the last element so far. What we see already when discussions have got to an interesting point in Parliament in 2015 about the potential triggering potential legislation on mandatory due diligence, that only with somehow, how do you say that in English? Only by using all the possible leverages that you have in the Swiss political system, it is possible to somehow so far keep the regulation on a rather weak level. And back in 2015, so there was a repetition of a vote that happened in Parliament to trigger such legislation. which is legal, but it's already showing that it's a very contested issue. And I think that same dynamic that continued during the parliamentary debate now over the last 3 years. And what we certainly have seen is that there has been much more support for robust mandatory due diligence legislation than there was in the beginning. So Anya mentioned parts of the business support for the substantial counter proposal that included civil liability with some restrictions. That was supported not only by the Groupement des Entreprises Multinationales, so by the main association in the French-speaking part representing multinational enterprises. It was also supported by the major other French-speaking business associations, also the ones representing SMEs and other parts and other cantons in the French-speaking part. And it was in overall supported by 8 business associations across Switzerland, especially the sectors of the retail businesses, the supermarkets, the textile sector, including the ICT sector. So there has been quite a coalition of businesses that have been in favor of such a solution. And I mean, that might be a bit my perspective, but I've been so much engaged in all those technical issues with parliamentarians, but also with very large companies. And I'm totally convinced that it's not about the technicalities of such a proposal. It is really about politics in the end. And the major Swiss business associations had decided from the beginning that they want to fight this out of probably quite different reasons than only business and human rights. So there is a whole question behind that. If it starts to have regulation on the business and human rights area, what does it mean on other areas of politics? And so somehow prevent further developments that might be uncomfortable. And this was a strategy really pursued during the parliamentary debate, and despite large parts of businesses supporting it. And it continued also in a popular vote. And I agree that the popular vote and the campaign, it has really turned incredibly intense and not, so that the last 2 weeks were quite crazy, and it wasn't constructive discussion anymore, which is somehow the nature of such a voting campaign. But the really constructive discussions, I think, have happened during the parliamentary debate, where even some of the multinationals, such as Nestlé, in the end supported certain, for example, Nestlé publicly supported the strong counter proposal with some amendments. And so you see that the companies being in the field for a long time might have a bit of different position than the business associations that not only in this field, but also in this field often just represent the least common denominator, unfortunately.
Thanks. You put a very good context there about why there might have been resistance. It's very helpful. Sarah, I'd appreciate your thoughts on this, please.
Yes, thank you, and hello everybody. So I might not go into the technical aspects of the referendum, and I think we heard quite a lot now about how and why it came to a referendum. Maybe what I wanted to add here and is we see this constant tension between voluntary measures and mandatory measures, and more also actors saying that voluntary initiatives and also the voluntary initiatives that a company can take are not sufficient. And I guess that this observation, which is more and more shared, is also what leads to increased demand for some form of regulation. And here I just wanted to share that this is also something that came up in Switzerland actually during the whole debate for the last years. And there has been several studies that were conducted that indeed show or demonstrate that companies are far from implementing properly human rights due diligence. Now, as Dorothee mentioned, one could say that this debate is still ongoing, and properly this this pedagogy was not very clear, but I guess that's one of the observation. And actually 2 years ago in 2018, 2050 conducted a study mandated by the government to assess to what extent companies do understand their requirement and to what is the requirements as defined by the guiding principles and to what extent they implement it. And the study pointed out a number of gaps. Mainly that these expectations are not clear, that while some companies do start to have policies in place, they don't properly refer to the guiding principles, and that there is a gap and an inadequacy between their commitment and the actual implementation, etc. So of course it's a study that is 2 years old, but I guess it's something that always comes out in the debate. The annual human rights benchmark that is being done also points out, I think the last one indicates that around 20 or 24% of companies properly implement human rights due diligence, and also a study that the European Commission has been demanding, and I think you were involved there as well very deeply, also points out that only very few here, I think it was about 1/3 of the surveyed companies say to have a proper due diligence mechanism in place. So I guess that this observation also leads a number of actors to say that if companies, if the private sector doesn't properly play its role and its responsibility, then a framework needs to be done. Now indeed, the initiative was not democratically adopted, so it's a counter proposal, and the counter proposal defining a different kind of scope. We'll see how to what extent it will reinforce or make this pedagogy around human rights due diligence more difficult or not. Maybe since we also mentioned briefly the European level, but I know that we will come back to that, I just wanted to briefly mention here that indeed in Switzerland, many companies and sector associations position themselves against the initiative. Interesting, however, to see is that some companies and actually several companies, including Swiss companies, do, however, support an EU directive, so a potential EU directive on human rights and environmental due diligence, which includes a priori also a form of penalty or civil liability. So indeed, I think Urs mentioned that it is interesting to see that, or one could wonder whether indeed it was rejected only for the technical specificities, or whether in fact it's not mainly a political concern, because this aspect might be present in an EU framework, but we'll come back to that later.
Well, actually, can I follow up on that, Sarah? Because you make a really good point. You have this breadth of knowledge, of course, with your work in the European Parliament and with the Swiss National Action Plan. How do you see the context of this popular vote proposal initiative within that bigger context? Because you have that expertise.
In the debates, you mean, or?
Well, I mean, yes. Well, actually, no, more broadly, where do you see the developments coming out of this in the context of other developments which you're involved in?
Yeah, well, so of course, and that was probably also a bit the difficulty in the timing. Maybe the referendum or the popular vote almost came too early or too late. It depends, because it is true that the expectations or what the initiative expected is quite avant-gardist. If you look at the general context, I mean, we have the French due diligence law, but it's a bit different, but would have been the first really ambitious law that is quite similar. Of course, now we are in this movement where a number of countries are ready to go in the same direction. So Germany, I mean, in Germany, there are now very severe and hard negotiations also about a legal framework, also about a law. And I guess they are ongoing the same kind of very heated debates that what we had in Switzerland over the last years. But Germany, or the German government committed to come up also with a very similar law as of next year. Other countries did as well. I mean, Finland, who now had the used to have the presidency of the European Council before Germany, so at the beginning of the year, is also pushing this agenda very harshly forward. So we see that there are a number of countries at European level, especially, that are going into that direction. But I mean, we still have to see what comes out. And of course, the European Commission is now ready as well. So it's quite interesting to see that after several years of also especially some MEPs in the European Parliament trying to push the Commission to come up with a harmonized framework, and that finally Commissioner Didier Reynders, so EU Commissioner for Justice, committed in April this year to propose a legislative text as of next year. Now we have there is a public consultation going on, but one should see a draft text for the first quarter of next year. So we see that single countries are following the same path than Switzerland and undergoing the same kind of heated debate, but at EU level there will most likely be a framework as well, or some form of directive or regulation. We'll have to see, but some form of frameworks. And a priori also Commissioner Didier Reynders was very clear that he wants this framework to have some teeth, so he wants a form of liability or penalty in there. And that will now have to be discussed and debated, of course. So somehow the Swiss Responsibility Initiative was clearly in that framework, was clearly going in that direction. Now the counter proposal is deviating from that a little bit. Also because we see that generally there is a trend to move more and more towards regulation, so more and more away from only voluntary measures to more and more regulated measures. And we see that at European level, at least, there is also a willingness, or at least a trend, for these regulations to also go beyond purely reporting requirements. Whereas the counter proposal makes a reference to existing directives or frameworks, for example, the EU Conflict Minerals Directive, which is in place in several years already. So somehow there is an anachronic thing here.
Thank you, Sarah. That's a great context you've put us in. Anya, what's your thinking on this, the broader context for what is happening in Switzerland?
Well, I think it's very interesting to hear all these different views, because it really makes you realize, so what Sarah was saying is exactly true. Switzerland, with the initiative, was ahead, and now it's slightly behind of the trend. I think that's certainly true when we're saying it's slightly behind the trend when it comes to due diligence. Again, though, if we come back to the question of civil liability, I think that really is an issue that's still very much starting now to be picked up. I think due diligence is a clear development, and the fact now that what has been adopted is more limited than what's being considered abroad is going to have to be dealt with. And there's already been indications from the Swiss government that, you know, they might have to go further than what the counter proposal now provides for, especially if there are significant developments at the EU level. When it comes to, you know, the context of the referendum and the civil liability point, again, I think it's interesting to see here that this was both the reason for the popularity, I think, of the initiative, and probably the reason that it was ultimately not successful. So you really had the fact that this issue was so strongly polarizing. It was an issue that was very easy to understand, to also to use in advertising. If you take the campaign both for and against, if you take the proponents of the initiative, you had a very strong poster of a child in front of a sort of a polluted background saying, you know, drinking water polluted, child poisoned, mining company liable. Simple message, which was very effective. And then on the other side, you had the opponents saying, the Swiss economy will be in the clutches of the international litigation industry. So, as I said, that really was, as we've heard, this polarizing point. If you look at the actual content of what was proposed, was it really that unique and special? Some say that, there was actually a basis in Swiss law already for what was being proposed. So for sort of a vicarious liability for a subsidiary company. We know that in various different jurisdictions, in common law jurisdictions especially, there are developments, there have been cases tried against parent companies for actions of their subsidiaries abroad in violation of human rights. I mean, there's the Chandler case in England, and there have been cases in the US under the Alien Tort Claims Act. Unfortunately, most of them not that successful. I do still think, though, that the creation of a clear and distinct cause of action against a parent company for actions of its subsidiaries abroad would have placed, as Sarah said, would have placed Switzerland sort of at the forefront of developments in that respect. And the French loi de vigilance, just to touch on that, it does go in the same direction, but it's much more limited for various reasons. First of all, the loi de vigilance itself is more limited in terms of the companies that it addresses. They have to be over a certain number of employees. They have to be large companies. I think the latest estimation was that it would probably only affect about 180 companies in France. And then secondly, one of the key points there was that under the French loi de vigilance, the plaintiff still has to prove all of the elements of the complaint. So it has to prove violation, causation, damage, and fault. And one of the key issues in the Swiss proposal was that it would have introduced a strict liability for parent companies with this possibility of a due diligence defense, which I think Nicolas mentioned as well. So again, to take the context and the relationship, when we're talking about the civil liability provision, I think it would have placed Switzerland quite ahead of other developments. I think Sarah rightly pointed out that this is now an issue that's starting to be mentioned in other countries and at the international level. I think it's also being taken up in the discussion on the treaty. But it's something that probably was just too early for the Swiss, who are never known to be pioneers in this kind of thing, to really feel comfortable with it.
Thank you, Anna, for your clear-sighted way of looking. It's really helpful. Now, Dora, you've got this extraordinary breadth of international expertise. What is your take on putting this in context?
Yeah, thanks, and yeah, for starting to contextualize, I want to add one aspect that I think is important for context as well, namely to look at the very few examples we actually have of mandatory human rights due diligence. And Robert, you know best about the UK and Australian Modern Slavery Act. And I think it's really important to highlight here that regulation per se is not the end game. So we're talking all about how do we get to regulation, but what we actually want is implementation and impact. And that's why I think we should look at the implementation of the few existing mandatory human rights due diligence regulations that have been put in place for specific issue areas. And what we see there is actually not that encouraging, unfortunately. So if you see how the modern slavery requirements in the UK and Australia have been implemented inside of corporations, unfortunately, this issue area has been relegated to the legal department, and it's been treated as a compliance issue rather than a business opportunity that should be at the heart of the core business processes, at the heart of operations. So it really narrows what business human rights could be, and it's becoming just another tick-off compliance issue. And that's not what we want. So it's not an argument against regulation, by no means, but it's something, again, that we should be very aware of as we draft regulation and advocate for it.
Thank you. That was punchy and spot on. I really appreciate that. For my final question for all of you, particularly obviously for Nicolas, Liz, and then Doro, is Well, what happens now? Nicola.
Oh, yes, Robert. So what's going to happen now? Well, first, I look forward to the discussion to what kind of implementation mechanism should be then in place. Yeah, for this final question of what's going to happen now, as we have many of us have touched upon, there has been the second counter-proposal, which is sometimes defined as the weaker counter-proposal or as a non-counter-proposal at all. Which has been used or debated in 2020 and adopted in June 2020. And that has been used as a political argument to say that if the Swiss Responsible Business Initiative is rejected in November this year, then the counter-proposal, this weaker counter-proposal, will enter into force. So first will be adopted and then entering into force if there is no further referendum on it, which is unlikely to be the case. I will now just show you the content of this second proposal here that has been adopted in 2020. Hope you see it. It's on the right side. So you can really see here the content. So there is really a different different concepts, a different approach. The first counter proposal that will probably very likely enter into force. We don't know when, probably at the end of next year. Aims to modify the code of obligation. So it's at the federal level, just like the first counter proposal. It includes a transparency obligation. However, this transparency obligation and reporting obligation is limited to, in fact, very large companies. About estimated 400 companies would be subjected to that new transparency obligation. It as well includes a due diligence obligation, however, only in two very specific areas. The first is a due diligence obligation that is limited to companies importing or processing conflict minerals in Switzerland, and limited to companies offering goods, for which there is a founded suspicion of child labor. I'm not very sure about what is a founded suspicion in this context, but this is the text of the law at the moment. Now, so you see the very big difference with the Swiss Responsible Business Initiative. Due diligence is not about internationally recognized human rights and internationally recognized environmental standards, but only in these two sectors. Now, what's going to happen is that the executive body in Switzerland will adopt an ordinance to implement these provisions, these new provisions, by putting the threshold above which the companies that import or process minerals will be obliged by this due diligence. So there will be a certain threshold to exempt maybe smaller importers or smaller processors of conflict minerals, as well as there will identify whether small and medium-sized companies will be as well excluded from these obligation or exempted from these obligation with regard to child labor, as well as other companies that are considered as low risk. We don't really know exactly what it means either. So this is what's coming for Switzerland. Obviously, you see here that there is no legal liability provision, or it doesn't mean that it's not possible to bring a legal liability case, just like now in the current legislation. But there is no specific liability for the damage caused by controlled companies. This was the reason why one of the reasons why the civil society did not accept this counter-proposal as enough to withdraw the Swiss Responsible Business Initiative. So this is not a coincidence, obviously, whether we have all these elements here of the counter-proposal. This has been a political game. Obviously, taking, for example, the non-financial EU directive, basing then arguments on the EU conflict mineral regulation, and as well as the Dutch child labor due diligence legislation. Now, there is another specific provision to what will be the content of these due diligence obligations in these two areas in particular. This is mainly based on the UN guiding principles, an obligation to identify risks, to take appropriate measures and take appropriate measures, as well as having a tracing system in the supply chain. But this is a very short article, and if you compare the very long conflict mineral regulation and the Dutch child labor due diligence law, obviously falls very short in comparison to these other types of regulation. Now, I just want to say one last thing with regard to legal liability. I think what is also, to answer your question, what is going to happen next with this kind of provision, we are in the situation that mainly I feared of having a very clear human rights obligation, even if in only two specific sectors, that will probably facilitate the argumentation and increase legal uncertainty, maybe, with regard to fault liability, by claimants having now the possibility to claim, well, you did not conduct your due diligence, you didn't do this, you didn't do that, in order to avoid a damage either in relation to conflict minerals or to child labor, and that could therefore open the door for new civil liability claims. So it really, we will see what happens with these kind of provisions in the future. My opinion is that this does not really, first, is sectoral, and second, it does not really improve legal certainty and clarity for companies.
Thank you very much.
Very happy to discuss this with
Thank you very much,
panelists.
because I think you've clarified just that it's not clear. So I appreciate that. Yes. Liz, what are your thoughts on what's going to happen next?
So I'm going to talk from the investor angle, which is somewhat narrower. I think that the fact that the weaker counterproposal will prevail is a setback for investors. Investors investing in Swiss companies will continue to be exposed to risks of poor behavior by these companies and risks of the lack of a level playing field. Yes, Switzerland will have some non-financial reporting requirement, but as my colleagues on the panel have pointed out, there are severe problems with that. And I mean, there's years of literature on the inadequacy of corporate reporting on human rights. And that's an inadequacy that has had serious impact on affected stakeholders because it throws the public off the trail, I would argue, by obscuring what's really happening on the ground. And it's largely left to companies to decide what and how to report. And I think there've been predictable results. And as Sarah pointed out, there's a push now going on in other jurisdictions to go beyond reporting in these emerging regulations. I would also say that besides those points, investors are themselves, at least in the responsible investment core, which, as I said, is a growing field, they're moving beyond simply relying on company reporting. In my own work, I see investors taking increasing interest in hearing directly from workers, hearing directly from local communities, from indigenous populations who are affected by corporate behavior. So, I think that there's a growing realization among a growing population of investors that relying heavily on corporate reporting is not the best strategy for their own work, which is to do due diligence on their portfolios. That said, investors, both Swiss and non-Swiss, are going to have to work with what they have. And I think it's an opportunity for them to be an important lever to hold companies to these requirements, as weak as they might be. And I just want to sort of flip it, because in the first round, I touched on the importance of investors for mandatory human rights due diligence. And I wanted to end with a few words on the opposite side of the coin, the importance of the mandatory human rights due diligence trend to investors. And I won't go back through what my co-panelists have done an excellent job laying out this emerging trend, but I would say that the train has left the station. Investors are increasingly publicly supporting mandatory human rights due diligence, and I don't think that's going to diminish. And I would argue from the investor point of view that mandatory human rights due diligence would make their job easier. And 2 examples, a law that brings companies up to the same level on required human rights due diligence would lessen the need for shareholders to constantly file resolutions urging companies to do better on human and environmental impacts overseas. I think it's also more efficient than leaving things to litigation. Investors themselves have started to sue multinational companies in recent years over losses connected to failure to disclose and failure to address human rights risks associated with operations. So I just point to the shareholder lawsuit against BHP, the Australian mining company, for the Samarco tailings dam collapse, which had horrific human rights and environmental impacts locally. So again, others have already noted that the EU is progressing on mandatory human rights due diligence. Other jurisdictions are doing so as well, and the Swiss investors are surely aware of that. We're not living in a bubble here. And I don't think that investors or others can remain isolated from developments outside of Switzerland, such as the increase in jurisdictions with mandatory human rights due diligence. And those could eventually implicate Swiss companies through supply chains and other mechanisms. So I think Swiss investors would do well to join or to continue to support, if they're already there, this debate on advancing corporate respect for human rights through mandatory human rights due diligence, and to insist on having a place at the table and a voice in shaping that debate. And one last thing, I just wanted to respond. I wanted to underscore a really important point that Urs made. He was contrasting the industry association's positions with that of Swiss companies. And that's a really important point on the investor side. We're seeing, at least within the responsible investment community, an increasing focus on the misalignment between the positions that trade associations take and the positions that individual companies take. And, I don't think that Switzerland is outside of that. I think it's an important trend for Switzerland as well. And the responsible investors are increasingly calling companies on it and asking them to be transparent about the misalignment between positions that trade associations take and their own positions. So I think that's going to be a hot point as well for Swiss companies.
Thanks very much, Liz. We found that exact disconnect in our study we did for the European Commission. There was a very big difference between what associations were saying, what businesses were saying. Now, just before I come to the Doro, can I remind everybody, please, to put comments in the chat or questions in the chat function, so we then have further questions to this. Doro, bring it all together. What's going to happen?
No, I thank my co-panelists for doing such a great job laying things out. I just want to, again, add things from a management perspective and go straight to your question, Robert, where do we go from here? So I think I feel, around the table, at least a portion of disappointment that there's no regulatory requirement now in Switzerland. But we have to work with what we have right now. So we do have a transparency requirement. We heard that. Liz pointed out that studies show this is really weak, but I've seen different reactions to such a transparency requirement. There are companies that then reach out to external consultants asking them to write a CSR report or something like that. And then others actually use that requirement to reflect internally and use the transparency requirement as a trigger to push internal processes and align core management processes with human rights. So I think this transparency requirement could be a hook, and again requires civil society organizations and academia to be vigilant and demand the reports, demand evidence for the reports, and ask lots of questions, how they came together, what actually happened. I'm also keen to point out that I find this distinction between mandatory and voluntary way too crude. It's a false dichotomy. We do not just have those two extremes. I think we have a middle ground, and particularly around the uncertainty what adequate human rights due diligence should mean in practice. I want to highlight that there are multi-stakeholder initiatives that have on an industry basis defined adequate human rights due diligence in real terms. Signing up for them is voluntary, but once you're in there, everything is mandatory. So I see those institutions as a middle ground between this polarized debate between mandatory and voluntary. this is an instrument we still have and we should use, and see how we can get companies to become part of such industry multi-stakeholder initiatives to further define adequate human rights due diligence. And then lastly, I want to also highlight that legality for companies is just one criteria. And I want to refer to the Rio Tinto case in Australia, where the company blew up Aboriginal caves, which was perfectly legal. Yet the outcry, the public outcry against disrespecting Indigenous rights was so loud that in the end, the entire senior management team had to go. From a business perspective, replacing a CEO is incredibly costly. So this goes to show that corporate legitimacy for corporations might be just as important or even more important than legality alone. And I think the transparency requirement and the watchdog function that many of us fulfill as independent academics, as civil society organizations, can support or can push companies to look into what's socially acceptable. That's the corporate legitimacy that they have to take care of. So I do think even without a regulatory requirement in Switzerland, and also Switzerland is not an island, we're part of a European Union, and I think companies based in Switzerland will have to pay attention to what's going on in surrounding countries. But even if we don't have in Switzerland, we still have a range of instruments that we have to really put to use now going forward. So I want to end on this encouraging note. It's not
that's great. Also, what you've done is you've shown things aren't as binary as they can appear. There's much more diversity in that, which is really helpful. Before I go to questions, Sarah, you wanted to add a quick point.
Yeah, very briefly, I remember things that you mentioned before, but that's actually a good now follow-up. So I wanted also to say that I think the merits that the whole debate now brought, even if one or some could be disappointed by the outcomes or having only this indirect counter proposal, is that I think it really brought the debate really further in Switzerland. And I think the awareness is much higher. And as Dorothy pointed out, I think the pressure is not going to disappear. I think the pressure comes from different stakeholders, including from the investor community and also from us as consumers. Of course, NGOs and all kinds of actors will continue to pay attention to what companies do and what companies say. Another point I wanted to mention is that if there is an EU directive in the future, I guess that the initiators or a number of actors in Switzerland will hope that the directive can be transposed as fast as possible into Swiss law. So there is also an opportunity then to align to some extent at some point with an EU framework if that comes together. And I just wanted also to come back to the Swiss National Action Plan that actually exists. Of course, it's only a framework, it's a guidelines, but just also to highlight that since 2016, the government has put in place a framework whereby also it supports and provides a number of support mechanisms to Swiss companies to also make companies aware and equipped with the necessary understanding of how to implement human rights due diligence. Because, and here I would also agree with what Dorothee says, having a framework could be one thing, it could be a driver, but still the question remains into how then to transpose that, especially when you operate in complex geographies across complex supply chain, and it's a shared responsibility, and certainly which certainly requires a multi-stakeholder approach and a two-way dialogue as well. So let's see how this comes together.
Thank you, Sarah. That's helpful. Now, there's a range of questions that have come in. Oddly enough, to some extent, one of them I think has already been answered, which was the question about whether this will enable sort of discussion within companies. I think Doro's put a really good point. It probably depends on the company whether or not it will actually consider these things internally. But one of the other questions says, what are your expectations of the effects of any EU directive in this area on whether it's implemented, whether there's an effect on the counter proposal at the moment or on any other legislation? Like, it's interesting, Nicolas mentioned, of course, that the two ones that are in the counter proposal, the second counter proposal, are existing EU law, or one's actually outside EU in the Dutch. So that's my first question, which I'm going to ask Nicolas and Urs to reply to in a moment. And then there's a question about what lessons can go in the other way. What can be learned from this experience for other companies, other countries, which are considering this? And I'd ask Anya and Liz to think about what they might think might be the lessons that could be learned for other countries of what's happened in Switzerland. And then there's a question about what about board levels? For example, audit committees, should they be considering this? I mean, interesting enough, because the European Commission is considering it at the same time as mandatory human rights due diligence, they're considering issues of governance. And I wonder whether or not, Doro, you'd be able to answer that one. And then there's a final question, which is for Nicolas again, looking at the specifics. Now, I might have to let you read that because it's a bit more knowledgeable about the specifics than I have. So I'm going to start with Urs, could you begin, and then Nicolas answer your two questions, and then I'll go to Liz and Anya and Doro, and then I'll ask Sarah to comment more generally on things. Okay, thank you.
So on the influence...
Please, all of you, be very brief, because you don't have much time.
So influence of the EU directives on the Swiss regulation, I think it depends on what directive or what regulation you're looking at. I think the impact of the NFR directive currently going on, yeah, I mean, there might be some influence to adapt the transparency regulation that is now entering into force. But I think much more interesting and substantive is the influence of the upcoming directive on corporate governance and the mandatory due diligence regime there. And yeah, I expect it will overhaul the Swiss regulation in a few years. And so that, I think, is the interesting debate to be followed. And there is no question that Switzerland has to act very swiftly if the EU is adopting that regulation. Please allow me to already go into the second question, where I would like to contribute 2 points.
Briefly, please.
Yeah. So the first thing, lessons learned from my perspective, is certainly coalition building is incredibly important, and it has to encompass all stakeholders, including in parties and politics, but also with companies and associations and civil society, and it takes years. And the second element I would like to mention is that civil liability is a sticking point, but you can't avoid it. So if you introduce legal duties, there are questions how it relates to liability, and you can leave it implicit. That has advantages and disadvantages. I think there are strong advantages of making it explicit what it really means, because it brings legal certainty. And what liability also is important is in relation to this discussion about adequacy and checkbox. And if you want to prevent that this is becoming a checkbox exercise, you need this question to leave it somehow to a certain extent open. And the question is really to find the right amount of openness and prescription, because it needs a certain openness that the company is forced to think what is adequate in this specific risk situation. And this is the element that prevents checkbox exercises and that makes due diligence meaningful. And we have to have regulation that meets that point.
Thank you. That's really helpful comment. Nicolas.
Yes, on the influence of the European Union, obviously Switzerland is not an island, as Doro said. We are in the middle of the European Union. So I think there has been this example before the popular vote, where we see how a very strong argument has been brought forward by Switzerland, or by some individual in Switzerland, that the counter-proposal would, the second counter-proposal would in fact bring Switzerland as a good examples with in comparison to its neighboring countries. So I hope that the same argument will be as well used after the European Union improved its own legislation. But obviously we are here in a very competitive global economy. Companies are fearing that they might lose consumers, that they might delocate, that there will be maybe a loss of employment, this similar argument that we hear from many corporate actors. And this is a reality that we have to take into consideration. So obviously the European Union plays a major role, and the development in the legislation in the European Union will definitely impact Swiss legislation as well. There is no question about it. I'm pretty sure about that. I think I'm going to leave it here.
Okay, thank you very much. Liz, what's your thoughts on the questions there for you?
So I would say, again, from the point of view of the investor angle on the lessons for other countries, I think investors are encouragingly actually reaching out to a wider and wider range of stakeholders. And this is to, it helps to improve their work that they're doing in terms of their own due diligence. As Urs said, I think that the broad alliance of the Responsible Business Initiative was a huge source of its strength. And I see that as a great lesson for other countries, you know, the way that this came together. And he pointed out to the earlier rounds where there was a lot of constructive discussion. And I think we can draw from that an important lesson. And, as it's gone over many times in this panel, no country can exist in its own lane right now, less and less the case with each passing year. And I think that we see through investment is a good example where you have, investors based in one jurisdiction investing in companies in others that have supply chains in other jurisdictions. I think a development in one place is going to have an impact on powerful stakeholders in other jurisdictions. I think that the initiative itself has provided lots of food for thought on how to advance corporate responsibility to respect human rights. And so I think despite the fact that the initiative itself did not advance in the vote, I think it's very worthy of studying and learning from it.
Thanks very much. Anya.
I think a lot has already been said, so I'm not going to be very long, but I do think if we're going to talk about one lesson learned from what actually happened in the end is that if there is a strongly polarizing element that needs to be identified early on, and that's where a massive effort needs to be made to bridge the gap and to then make sure that the dialogue continues with the relevant stakeholders. As soon as that becomes the focus, and as soon as there's a spotlight on this issue, it becomes much harder to have meaningful dialogue and to ensure that if then regulation is adopted, it has taken into account the concerns of the various actors, of businesses, that it then, leading on to what Doro said, is actually implemented. Because I think what was a big shame in this case is that the human rights due diligence point, which ultimately could have had a great deal of support, probably ended up being weaker than I think it could have been, because there was such this strongly polarizing element of civil liability, and that sort of led to things falling apart a little bit. And I think that really needs to be a lesson, in other countries, which of course don't have the same system as here. This is a very specific Swiss system of direct democracy. But that if you're going to have a dialogue, identify very early on what the polarizing element is going to be, and either decide whether that really does need to be an essential factor of the next step, or whether you might focus on the elements that are common and try and build those up first. I agree with Urs that civil liability, of course, has to be addressed, but I'm not sure that in this case it was necessary. It was not just addressing the consequences of what due diligence would have meant. It was actually going one step further and introducing essentially a new course of action there.
Can I just ask one follow-up question? And you're advising these companies, of course. For them, does it matter whether it's law or not?
Well, I think it goes to what Dora said. It matters in that that's who then is coming to us. So, we are being approached by legal compliance, and, of course, that's who we interact with. And I think it matters in the sense that it turns it potentially into a risk rather than a positive and a business opportunity. I think Nestle was very strong on that point as well. You know, they say if it becomes law, it changes the way we look at it. It changes how we address it, where we address it within the company. They find it often quite hard to bridge the gap between the legal compliance view of things and then, you know, those who are dealing with ESG from a, you know, from a more positive aspect. So yes, it does affect it, of course, because they see it then as a risk.
If I may just ask, what kind of civil liability would businesses have endorsed? The question is maybe for Anya.
Yes.
Well, I'm not sure I can answer for all this.
Maybe wise not to answer that question.
I'm not sure I can answer that one really, especially as I can't even pretend to have spoken to broad enough spectrum of businesses. I mean, you know, there are some businesses who would have accepted a civil liability. I'm sorry, Nicola, I don't really think I can answer that one.
It's a great question, hard one to answer. Doro, your thoughts?
My question was, how does this affect boards, or how can human rights expertise become part of boards? And I'm surprised that Liz didn't mention the great interest of investors to diversify boards in terms of climate change expertise. And I think here's an opportunity for human rights advocates to use that hook and say, well, it's climate change and human rights, inequality and climate change as the two mega topics of our times, diversifying board expertise and bringing human rights to the highest level of decision-making in a corporation certainly would make sense from a corporate legitimacy point of view. Again, how do you manage things that may be legal, but simply not socially acceptable? That's, as I pointed out before, equally important for a corporate success. So it would make sense to bring that in.
Great, thank you, really helpful. And Sarah, last word to you.
So maybe one thought and one question about the lessons learned. I think it's important to keep talking about in practical terms. I think we are in an era where we like to simplify sometimes the messages, to bring some headlines. And I think it's important to continue talking in practical terms and continue questioning and working on the implementation challenges and in their complexity to find the appropriate solution, which might be complex as well. So that's one point. And the other point is that I wonder what influence now the outcomes of the Swiss vote will have at the EU level, whether now the debate will go more towards reinforcing indeed the civil liability or penalty clause that might be foreseen, or in contrary to dilute it, because they could say, see, in Switzerland, where the question was posed to the society, to the people, it was not in majority or in the majority of cantons supported. So I'm curious to see in the other way around what impact it is going to have overall.
That's a good point, and there may be a focus on the popular vote rather than the canton vote for that purpose. I guess everyone will have different ways forward. Well, this in perfect timing brings us to the end. I'm going to just say something briefly before I pass to Claire. I mean, just thank you so much. The diversity, the engagement, the knowledge, the expertise, and the ability to interact with each other is just superb. And it's a great credit to you all that you're able to do that in such a high level, but a very accessible way. And all I can say is thank you enormously. It's just, I immediately thought I've got to get my students to listen to this seminar because it's just been so brilliant. So thank you so much. And I'm going to pass you across to Claire.
Thank you so much, Robert, and thank you to all of our speakers for this extremely insightful discussion. So I wanted to thank also all our participants and let you know that we'll have the last episode of our webinar series on business and human rights developments in Southern Europe, which will focus on Greece. That will be on the 12th of January. And the other thing I wanted to mention, we've talked a lot during that webinar about the relevance of the developments going on at the European level and at the Nova Center for Business, Human Rights and the Environment. We are currently preparing a webinar series which will focus on these developments to coincide with the Portuguese presidency of the Council of the EU. And the first webinar will specifically be on that link between corporate due diligence and civil liability, and how do we translate that, and how could we translate that at the European level in the proposed legislation. So if you're interested in these problematics and these thematics, please follow us. We will publish all the relevant information about the events on the social media. And thank you all again for a great webinar. Thank you very much and have a great day.
Thank you.